Hello and welcome to another segment of Western Wisconsin Journal. I'm Jamie Johnson, the legal and government correspondent, and I have three guests today, all of whom are on the staff at St. Croix County District Attorney's Office, and we'll introduce them and let them talk about themselves a little bit, their background anyway. First we have Megan Kelly and Ed, last name?
Mincer.
Mincer. I was going to get the pronunciations before we went on camera. I didn't do that. And Matt?
Hartung.
Hartung. All right. So, and we have kind of an order with Matt. You're the one that's been with the DA's office the longest. So why don't you go first? Tell us a little bit about where did you go to school and what were you doing at the time that you took the job here for St. Croix County?
Sure. I was raised in a very small town, Bertha, Minnesota. Both of my parents were high school teachers, and that's kind of what prompted my interest into to public service. I went to St. John's University in Collegeville, and from there I took communication classes, writing classes, English classes, things like that. And after graduation, I volunteered for a year at the AmeriCorps program in St. Paul and made the decision kind of in that year to go to law school. The following year, I was accepted and I went to St. Thomas School of Law in Minneapolis. I met my wife in Milwaukee and ultimately transferred to Marquette to be closer to her. And so the day after,
she's from Milwaukee?
She's from the Milwaukee area, yeah.
Okay.
So
you transfer from St. Thomas to Marquette?
Yep.
And graduated from Marquette what year?
May of 2013.
Okay.
And the day after I graduated, I moved back to the Twin Cities and started volunteering in the DA's office here in St. Croix County. So that was kind of my in to the office, I guess you could say. I volunteered there for about 6 months, and I didn't upset too many people, so they asked me back when they had a position open up a couple months later. So. And
as we talk with the other assistants, I understand they have a program here. We've got how many total prosecutors now in the DA's office? Is it 6? Is that right?
I believe so. 6 full-time.
Okay, and but not all of them are state attorneys. There's one county-funded position. Is that correct?
Yes.
And is that something that you were involved in originally?
Yes. I once, in June of 14, our county funded a drug prosecutor position. And so one of our former prosecutors who left for the AG's office, Amber Hahn, then shifted her focus primarily to felony drug offenses, and I slid into that county appointed position that Megan has now. So.
Okay. Ed, I'll have you go next because, why don't you give us a little bit about your education and background?
Right. Like Matthew, I come from a small town in Minnesota, the Chisago Lakes area. So that's where I grew up, but I initially jumped the river and came over to Wisconsin to do all my schooling. So I graduated with my undergrad degree in political science from the University of Wisconsin-Madison. From there, I took a year's hiatus in our nation's capital, went out to Washington, D.C. to try and find some interesting things to do, but found myself coming right back to Madison that year later to begin law school. So I went to UW-Madison for both my undergrad and my law school degrees. Met my wife at UW-Madison Law School. She graduated the same year as me in 2012. I was very much interested in prosecution right away. I enrolled in something called the Prosecution Project, and that's a really great program for young attorneys who are interested in doing trial work, interested in getting in front of a judge right away. So in between my second and third year of law school, I had the opportunity to intern in a district attorney's office, and I interned with the La Crosse County District Attorney's Office. And right away got to get in front of judges, get my name on the record, make arguments, do motion hearings, really interesting stuff like that, even before I had my law degree. It was a really good in for me, just like Matthew had here at the St. Croix County District Attorney's Office. So I was offered a position as an assistant district attorney in La Crosse. It was about a month and a half before I graduated, so I had someplace to go right away, which in 2012 was a pretty good thing to have. And I swore into the State Bar of Wisconsin a couple weeks early and started working right after I graduated. And when they...
Which was what month and year?
It was May of 2012.
Okay, May of 2012. All right.
And right away they had me prosecuting the drug cases for La Crosse County, as well as some gun, gang, and burglary type offenses. So right off the get-go I had a fairly large caseload that was felony heavy, and for a young prosecutor that's a pretty good thing because I had a lot of opportunities to do evidentiary hearings. I did a lot of preliminary hearings, usually a couple a day. So it hones your skills in conducting direct examinations, things like that. So I spent a little over 2 years doing that in La Crosse, and then I spent my last year and a half in La Crosse working on sex assault cases, sensitive crimes, crimes against children, and a position to open up in St. Croix County, opportunity to bring me closer to family. So I accepted the opening here in St. Croix that Ms. Hahn left when she went to the AG's office, and now I'm prosecuting the felony drug cases here.
Okay, very good. Great history there, but I don't know if you mentioned, you sent me an email, and I also read the newspaper article. You're the one that had the interest in the show Law and Order, right?
That's right, yep.
And so
very young age.
Okay, so you were watching those, you never missed an episode, and that's what made you want to be a prosecutor then?
Yeah, I really loved watching my Wednesday night Law and Order fix. I really liked the show, watching through the procedure, watching through, these weird rules of evidence that they had to follow, even sometimes when they seem silly, when you know that a little bit more information that the jury doesn't get to get. And all those little intricate details I really fell in deep interest in.
And then once you got your law degree, you realized too that some of the rules they cite aren't necessarily true of all jurisdictions and so forth. So.
Yep, differences between different jurisdictions. Normally they teach in law school, at least they often teach the federal rules, and there's some slight differences between the federal rules and Wisconsin's rules.
So with you graduating from Wisconsin and you graduated from Marquette, you didn't have to take the bar, correct?
Yep.
Correct. I took the bar in Minnesota the summer I was interning here, so I like to say that I
still took a bar.
I still took a bar.
All right. And then, well, last but certainly not least, Megan, you, speaking of jumping the river, you went to law school over in Minnesota, William Mitchell, and you did have to take the bar. So why don't you talk a little bit more about how you got into law school and why you became an attorney?
Well, I'm originally from Virginia, Minnesota, which is also a small town like both of them, and it's in northeastern Minnesota. I went to college at St. Scholastica in Duluth, where I got to intern for a county attorney's office and just kind of fell in love with criminal law. I've always been kind of a rule follower, and I like rules and order and procedure, so criminal law was kind of a natural fit. Then I went to law school in the Twin Cities at William Mitchell, and I just graduated in the spring, and during my final semester I got to intern in the St. Croix County District Attorney's Office, where I got to work full-time. Similar to the prosecution project that Ed did in La Crosse, I got to work through the criminal law residency full-time in St. Croix County. And so I got a lot of courtroom experience, writing experience, and really loved the job. So I took the summer off to study for the bar and fortunately passed, and they had an opening and were willing to keep me around.
So, and you're the attorney that has the county position then?
Yes, and it was kind of a perfect fit, so.
Okay, great. Well, I was in your position at one time. I started as a prosecutor after having an appointment to the Court of Appeals as a judicial clerk, and that was a generation ago, so the pay was much different. I think I started at around $24,000, and when I left, they had just made us state employees and were unionizing and topping the $30,000 mark. What does an entry-level prosecutor now make? Do you know what the schedule is?
I think it's approximately $49,000 starting off.
49. All right. So it hasn't quite doubled in 27 years. All right. And so that's how you got into it. Now, you also, each of you spoke about different programs and all had that hands-on experience. Madison was kind of, when I went, again, almost 30 years ago, they were known for their clinical programs, and yet they still only had a fraction of what they have now. And it was unheard of for you to go outside of the Madison confines for that internship experience. So you actually interned at Croix, and you were over in Marquette. Were you able to also have experience in other
Yeah,
areas?
I did a judicial internship at the Milwaukee County District Court, and then I was a intern for the Sheboygan County District Attorney. So similar experiences that Ed and Megan had, being able to go into court as an intern, a law school student, and do hearings. It was a good way to get my foot in the door and gain some confidence.
Those are unpaid positions, but you do get credit towards your diploma then? Is that?
There was a small stipend, but very small.
Very small in the case of your experience, but still, I imagine your experience wasn't that much different from mine, even though mine was a long time ago, that you learned a lot more doing the hands-on and being in the courtroom than you do in the classroom, hearing a professor lecture about theory, right?
Absolutely.
It's
So
a good way to see kind of the classroom come alive. I mean, you hear about things, but to actually see it work was beneficial for me.
Right.
In learning the procedure and how to conduct hearings and so forth.
You know, and the other thing that you learn soon is that every case has peculiar facts. You know, no two cases are going to be identical. You start seeing patterns, perhaps, but how the law may get applied in every situation, it's not always as cut and dried or black and white as folks think. Sometimes it's hard to tell. And have you all done ride-alongs with police? Is that something that you've done?
Yeah.
And so you've seen the responses to domestic abuse incidents, and it's also very hard sometimes to figure out who's the aggressor, who's the one that should be arrested, and who's the one that's the supposed victims, and many times they're both arrested, right?
Yeah, I got to go on one in the spring as part of my internship here. So I went with a sergeant from the St. Croix County Sheriff's Office. And he was really great in explaining everything to me. And just to see the decisions he would have to make when you come upon a situation, you know, he had to make a decision on how to handle it right then. As lawyers, we sometimes get a little bit more time to think about things. So it was really neat just to see his thought process. And I have a lot of respect for what they do.
One of the things people say, how do you determine how big of a staff? Because more than 25 years ago when we were in Eau Claire, even though our county was twice as big as St. Croix had more assistant DAs than Eau Claire did. Now part of that was, you know, function of the number of cases and so forth, but how many, you said you had 6 total here. I think the important thing is you have at least as many assistant DAs as you do judges and court commissioner, right? Because in theory, you could all 5 be in the courtroom at the same time, correct?
That's right, yeah.
5 of you could, and so to have at least one extra prosecutor helps. And I know they were at, they've been at, well, they've added a branch in Eau Claire since I was a prosecutor there. And so you're trying to cover different things. Now, they still do that here? Are you kind of assigned to different courtrooms? And I know now they have also a drug court with Judge Fleck, which is a totally different thing. But generally, do you see this kind of mostly the same judge, or is it vary?
That depends. Most of the attorneys in the office have a specific judge that they're assigned to. The way that works for me is I have a specific caseload, so I take felony level drug cases that come in any given day. So there might be any one of the 4 judges that are on intake at that time. So I have cases before all 4 judges. Mr. Nieskis in our office also has cases before all 4 judges. And then the other attorneys are generally assigned to a judge for intake, but their cases might, whether it be from substitution or something like that, might have cases also before another judge.
And we could do a whole show just on the drug court piece of this, but there's definite advantages to having one attorney prosecuting those felony ones because of just the nature of the work and the different treatment programs available, and I'm assuming that's why they do it, right?
Right, and you work very closely with a task force. We have a drug task force in St. Croix County. It's the St. Croix Valley Drug Task Force. So you start to develop a close working relationship with a certain set of officers. So sometimes it's nice to have one specific prosecutor that they can come to who might know about some ongoing cases or might have some familiarity with specific defendants and have some specialized knowledge in some of the drug world. But it is also incredibly beneficial to have one attorney who understands what's going on for also addressing those treatment side issues. Now, the drug court is something that I haven't been assigned to at this point in time. That is still Mr. Nieskus who's handling that.
Okay, so Mike is handling that at this point. But aside from the obvious cases where somebody's caught with 50 pounds of illegal substance, whatever narcotic that might be, or manufacturing methamphetamines or something like that, there's still a lot of bleed over with the misdemeanor drug charges with other crimes. I mean, between alcohol or drugs, that usually explains the vast majority of crimes that are committed. So what have you seen in the time that you've been here as far as what's offered in this county versus what other counties might have available? And I guess you two with experience in other Wisconsin counties, either one of you could respond to that.
Well, a lot of our, so I'm assigned a general caseload, and I think you hit the nail on the head. A lot of the behavior that leads to criminal charges, I think, is largely influenced by substance abuse or alcohol abuse. One thing that our county has done, we have a diversion program for, typically it's aimed at first-time offenders, and it basically is a lighter form of supervision than what probation would afford, but that also provides incentive for the defendant to seek treatment, seek programming, and then if they complete all the requisite requirements, whether it be an alcohol and drug assessments or other types of programming, they get the benefit of a dismissed charge or an amended charge at the end of that agreement. So I think our diversion program is one way that we've started, and I think I started in the office right when the diversion program came to be. So I think it's relatively new, but thus far from what I'm hearing, it's been successful so far.
I think actually it was an expansion of the diversion program. I think it's been around since 2005, but they had special funding from something called a TAD grant in 2014 when Matthew came around. That does specifically target people with substance abuse problems.
Again, that's another program. Wasn't available 25 years ago when I was prosecuting. Was nothing formal anyway with a diversion program. It was either you were a youthful offender, under the age of 25, and you could be eligible for expungement. But other than being eligible for expungement, there wasn't really a way to deal with people, and they would end up with, criminal histories that for conduct that, again, is usually one time and done, especially if it's the result of narcotics or exposure to drugs, where you treat that problem and then the person becomes law-abiding. I mean, that would be the goal, correct?
Right, and our diversion program is even more robust than that. It does handle more than just the substance abuse issues. It certainly makes sure that if somebody has substance abuse needs, that those are taken care of. But a lot of evidence-based practices have found that it's more criminal thinking is one of the more primary issues that a person might have that causes them to commit crimes. So our diversion program addresses the criminal thinking along with those substance abuse issues. So it goes a really long way, and we do have 2 full-time diversion coordinators and a part-time as well that oversees the program. It's very robust.
The diversion program, that would be, though, for non-violent, non-violent felony cases, correct?
Yes.
I mean, it's pretty rare to put diversion program on somebody that's committing some kind of violent felony crime. But our violent felony crime is not, it doesn't take up an entire prosecutor's caseload here, does it?
No, there's not a specific prosecutor assigned to that.
Okay. Now, but we have had people at this table with experience in homicide or attempted homicide cases. Why don't you talk about that? I guess my entry into this or segue is, interesting cases that you've worked on, and I think, Matt, that was one of the ones that you worked on, was a shooting case here.
Yeah, and actually Megan was an intern during that time, so she was helping on that case as well. That I think the reason I cited that case is it had a little bit of everything. You have, I mean, the basic facts were a person came over to buy liquor from Minnesota to Wisconsin because Minnesota doesn't sell alcohol on Sundays, and got into a heated word exchange with another group who was doing the same thing, coming to Wisconsin for alcohol, and took out a firearm and shot 6 times at this vehicle. 3 people were hit, and the way the case developed is that this person chose to represent themselves, which is somewhat unusual, but given the severity of the charges, it was extremely unusual. I think that this person decided to be a pro se defendant facing some serious felony charges, and it presented uncooperative witnesses. It had other acts evidence, which is evidence of another crime or act that was separated from the crime itself, that we used to convict.
So the judge had to make a ruling about this other
Yes.
act, and was that a ruling that was favorable to the prosecution? That
Yes,
helped prove the case?
it was it was an issue with identity. So the handgun or the firearm wasn't recovered. However, days prior, before the Hudson incident, the handgun, there was a photo of this person with the suspected handgun, and it was involved in a shooting in St. Paul. So that was something that was interesting to litigate before the trial, because a large part of our case in proving the identity of the suspect rested upon that other act's evidence. So that was another twist to that case. The other attorney was Mike Nieskus from our office. So the 3 of us took it on. It was about a week-long trial.
And resulting in convictions?
Yes. Yep.
Was there a prison sentence then?
Yes. I believe he was sentenced to, was it 50 years?
That sounds about right, probably.
Okay. Now, I want to hold that thought, too, about the pro se, because I have a follow-up on that. But, Ed, do you have kind of an interesting case, then, that you've been involved with, whether here in St. Croix or in La Crosse, where you were before?
Right. I was involved in a very interesting one while I was still in La Crosse and still a fairly new attorney at the time. There was a double homicide that really shook the community down in La Crosse. It was an early Saturday afternoon in a camera store right downtown. It happened sometime between, I want to say between 1 o'clock and 3 o'clock in the afternoon, right as the camera shop was closing down. A man remained in the store and shot both the shop owner and the shop owner's son and killed them. It took a long and very law enforcement intensive effort to track down this individual. They canvassed the entire downtown area for surveillance footage, and they were able to piece together all these different views of this suspect to try and identify the vehicle that he drove away.
The camera shop had security cameras?
The camera shop itself did not have security cameras, which is what made it incredibly difficult for us to prove it, to see the actual individual that did it. They identified a minivan that had a hitch that was turned upside down.
Okay.
And then law enforcement from DCI and the city. And
now, how did they develop the motive? Was that through interview of the suspect, or was it through the circumstances of the shooting that they had an apparent motive? Motive
came after first identifying the suspect. Motive came from checking bank records, things like that. So it was a financially, at least is believed to have been a financially motivated killing.
Okay.
For stealing camera equipment. And I was involved in it from the day of the shooting. I went to the scene and observed the scene. I was involved in the investigation, at least part of it, and trying to track down the individual and then assisting.
So were there other charges in addition to the homicide, double homicide? Was there like theft charges that?
There was a robbery.
Okay.
There was a felon in possession. The man had a prior felony, so he was a felon for possessing a firearm.
And then I assume that there was a prison term?
Right, yes. Guilty on all counts and 2 life in prison sentences.
Did that person have private counsel, pro se, as in Matt's case, or public defender?
He had a team of public defenders. He had, if I'm right, 3 public defenders.
Okay. And with a public defender case, then the appeal is almost automatic, and,
right.
And the convictions withstood appeal.
I think that appeals are almost automatic in most homicide cases. It did withstand its appeal, at least through the Court of Appeals at this point.
Okay. So it's still in the system, so to speak. Do you have another one besides the double homicide or the attempted homicide that Matt referred to?
Well, I think the benefit of being an intern, because I was an intern for so long, I've only been an attorney for a couple months, is I got to work on a lot of different cases because the bigger cases are the ones that the attorneys need the extra help on. But really the one that stands out was that case because I had these 2 experienced attorneys, Matthew and Mike, who were willing to carve out a piece of the case for me to kind of make my own. And I learned how to put together a trial that week, and it was just awesome that they were willing to let me be a part of it.
Okay. I want to get back to something you mentioned, Matt, about the pro se aspect and being a little peculiar, but actually, would you say, and this was my experience, but it was, again, a little bit aged, is that at least half, if not more, of the criminal charges that are out there, people don't get an attorney. Everyone has this notion of, because of the Fifth Amendment, they've got this right to counsel that, they're automatically going to get an attorney, but Wisconsin has some pretty strict financial qualifications for public defender, and so many of those people that make even minimum wage job, if they work full-time, they don't qualify. Is that still the case, or have the qualifications been loosened so that more people can have public defenders in that situation?
I think a tool that's utilized a lot in our county is a lot of defendants have the benefit of applying for a county-appointed position or a county-appointed attorney, and so what that is they have a private attorney, but they pay through the county at a much lower rate.
Then what, a private attorney, if it was $250 or $300 an hour, these are like $100 or $110 an hour?
Yeah, I think they set up a plan with the county to figure out what they can afford, and then they're on a payment plan until they can pay off the funds. But I know
so the attorney's paid actually by the county as the funds are earned and the case is closed. The attorney doesn't have to worry about getting the money from the defendant later, but then over the course of the probation or whatever, I guess if it's an acquittal, then they don't have to pay it, or what happens?
I believe they still have to pay their attorney's fees.
Okay.
I'm
even if they're acquitted?
not intimately aware of how they go about paying it, but if they are appointed an attorney through the county, they still have to pay the attorney's fees, but they're given a payment plan through the county.
Yeah, but it can be several $1,000s, and then when you add on top of it restitution from a particular case, could be a situation where they're paying like a lot of their paycheck. If they're fortunate enough to still have a job after they have a criminal record, then they're paying, trying to pay that back. Generally, is the restitution paid first, or is it the county? Do you know?
I think the restitution gets paid first. I think that's the number one or the primary place to where any funds go is to make the victim whole again.
Another very common area for a prosecution is bad checks, and worthless check, again, something that all prosecutors generally handle in your office. Does it, because those are
rarely. I think we farm those cases out to another firm or.
Okay.
Are you aware of what we do with the bad checks?
Yeah,
I had a couple of them.
But
okay. But well, it's so rare for those to actually be criminally prosecuted because you have a sort of a diversion program in that you give people that opportunity. Usually they get the dunning letter, from the prosecutor's office. That's what we did in Eau Claire anyway. If somebody failed to pay a $74 fee, the merchant would bring in the check, and then the rule was if we had to send 2 letters, then we would issue a charge. Usually, if the letter didn't get the person to pay the bad check, which they'd also have to pay the processing fees and usually a surcharge on top of it. But if they didn't pay after getting a couple letters and then a criminal charge would come out, even then they would if they weren't paying because they didn't have the ability to pay, they'd put on some type of diversion plan where they paid over time and then they don't end up with a conviction.
It previously was my caseload.
Okay.
Having worthless checks when I was in my days in lacrosse, and we had something called a check requisition program.
Okay.
And that was something that was, as Matthew said, farmed out, and I think that's very similar to what we have here in St. Croix County. So it allows people to have an opportunity to pay, what they owe and avoid having criminal charges issued.
Okay. Another area of specialty would be juvenile cases. Do you all handle those, or is there one attorney assigned to just do juvenile cases?
There are two attorneys, Sharon Carell and Alexis McKinley in our office, that specialize in the juvenile cases that come through St. Croix County.
Now, I understand that is it still pending legislation? It didn't pass yet about possibly making that prosecution age, raising it from 17 back to 18 where it was before?
Right, that's still pending is my understanding right now.
Okay. So, and then is there anything, some of this stuff is also discretion, and that's what drew me to be a prosecutor, was that ability to have justice, within the bounds of the law and make a difference that way. Have you had that ability to exercise? I know that you've only been a couple months, but have you had a situation already? And I'll ask the other two who've been a little bit longer. Think of examples where you felt like, yeah, I could, with the letter of law, come down on this person, charge them criminally, send them to jail, that type of thing. But that's not, what we're here for, is to put everybody behind bars, but rather trying to achieve the other goals of the criminal justice system.
I think that that's one thing that I learned really quickly my first week, learning that you have to make these decisions, because a lot of times people who are charged with crimes have maybe mental health issues, or there's something else going on there, and a criminal charge may not be, or a criminal conviction may not be the best way to address that. That's, like we were talking earlier about the diversion program. I think that's a great way to help people meet some needs that they can get through that. For example, various assessments that could lead them toward a treatment path, or various group situations. And I think that, sometimes when I came into it, I thought, oh, I need to charge everything that comes on my desk, but I've learned that's definitely not the right way to go about it. You have to look at each case individually and think, should this person actually be charged? And if so, how to move forward that way.
You guys have
I think we
situations?
probably exercise our discretion on things like that every day. I mean, for me, when I get a referral or someone that's, got some, a situation where I could charge out an array of things, I think you have to stop and think ahead as to what's the goal of this particular prosecution. Is it, to prevent this person from coming back in the system again? Is it to give the victim, if there is a victim of the crime, some sense of justice? Is it to punish? And I think that once you have that mindset, then that really assists in deciding what charges to file, how many charges to file, and
I'll give you an instance too. Domestic violence. And again, when I graduated law school, there wasn't even the rule of you have to have an arrest hadn't passed yet. That came shortly after, like from the late 80s anyway, so the law's been around for more than 25 years now, but many instances there where charging the person with a crime can end up harming the family because it presents a lot of financial difficulties. Maybe that person ends up losing their job and their support. And then, but competing with that is that enabling syndrome that you have with victims who will cover up. Many times they retract or recant their story that they've told the police that got their arrest in the first place. The next morning they realize that they did something wrong by reporting it to the police, and then they take the blame. So those are tough situations. Have you had those on a fairly regular basis to make those decisions when you go pull the trigger, or where you go maybe with a diversion before you start getting somebody's record involved with criminal charges?
I think one tool that's been really useful for me in those situations are the other attorneys in the office. Obviously, I'm the least experienced person, but everybody is so willing to help, and also consulting with the diversion program. Would this case be appropriate for that? Another piece of advice that I was given early on is consult with the officer who referred it up, because that person was actually there, and consult with the victims, which is a piece of advice that Ed has given me frequently, you know, talk with the victims. And I think those things have always helped me come to a decision that I'm comfortable with, but I think it's always going to, every case is different.
Okay. Well, so when you're, this ability to exercise discretion, like you say, on a regular basis, do you think that it's the judge's job to worry about who's going to jail, or is that something that prosecutors also can assist with those decisions? You know, I've seen a couple articles recently about this over-incarceration problem, and I use quotes around that. But compared to other neighboring states, Wisconsin has really high incarceration rates, the percentage of our population, especially minorities, but that are in jail compared to our neighboring states, and then just the whole national average, we're well above that. So I guess how would you answer that question?
Well, I mean, first and foremost, it's not our decision whether somebody is incarcerated. It's that decision ultimately.
But you make
lies with the
recommendations
judiciary.
in every case, right? And the judge hears argument as to whether somebody should go to jail or not.
That's right. And as we talked about a lot earlier, part of that discretion that we exercise is we're not asking for maximum sentences. Very rare, in the most rare of circumstances, will we make that type of a recommendation for the largest amount of incarceration possible. Many times, even on cases that are felony level, there might be somebody who doesn't need punishment. You know, we might be having other goals of prosecution that we're looking more towards the rehabilitative needs of this individual. We're looking at making a victim whole. We're not necessarily looking at strict punishment on an individual. So we might even have a felony level case where a person doesn't serve any bit of incarceration. But there are some times where we feel that, you know, punishment is necessary, and then that's where a short jail time, a lengthier jail time, or prison might be appropriate. But we have a lot of tools at our disposal, especially in our office with our diversion program, that we can avoid that.
Well, there's the diversion program. There's also a tool that's used quite a bit on conduct that is technically a felony, but one where you can charge felonies and misdemeanors, convict them of the misdemeanors, and then kind of do a deferred on the felony and kind of hold that over their head. It's amazing how corrective that can have, corrective effect that can have on their conduct, and they actually gives them a huge incentive so that they're not considered a convicted felon for the rest of their life. Talk about that a little bit, about the role that plays, because I think there's a misnomer in the public about, they hear plea bargain and they think that that's derogatory, that plea agreements, but without plea agreements, our criminal justice system would come to an absolute halt if you had to try every single case that was in the office.
Right. Just to give you a number on that, I think it's very typical that about 1% of cases are the ones that end up going to trial. Most cases do result in plea negotiations. If that wasn't the case, probably nothing would get done. Trials are very risky things for both the defense and the prosecution, and there's most often common ground. Yeah, that's very often why we have these plea negotiations. And what you're referring to was something that we have a very technical term for. We call it a deferred judgment of conviction. So we ask that a person take accountability for what they did. They end up pleading to something that's a felony.
Often it's a guilty plea as opposed to a no contest plea.
Correct. As well as pleading guilty to a misdemeanor or two. And then the conviction for the misdemeanors is placed onto the record, and then they go on probation for that. While at the same time, they have this felony conviction, but it's not entered into the record. They're allowed to attempt to complete probation on the misdemeanors, and then if they're successful in that, then that felony will be dismissed at a later time.
Right. And you had some time down in La Crosse, and you're more than a year here. Have you seen instances where people that were sentenced under that, put on probation on misdemeanors, and then had a felony? Have you seen anyone violate their probation and have to go back and then in front of the judge and be sentenced on that felony?
Yes. Yes, I've seen revocations, and I think that also comes in with our plea negotiations as well, and our discretion that we have as prosecutors. A lot of times we could draft or pitch certain plea negotiations that would ultimately set the defendant up to fail, and that's not what we want to do either. So we want to, the deferred judgment of conviction I use a lot. It's a way to craft a resolution to a case in which ultimately you put the ball in that person's court and say, okay, if you're making all these promises that you're going to change and you want to get better, you want to get treatment, well, okay, let's see you do it. And then if you're successful, you get the benefit of no felony conviction, and if you're not, you come back. And a lot of times, it's what we talked about earlier, when deferred judgment of conviction is revoked, a lot of times it's due to substance abuse and behavior on that. So with these type of agreements, we don't necessarily want to set something up to where the person's just going to fail later, but sometimes it does happen.
Would you say that one of the things when Hudson was going through its heroin addiction and the unfortunate deaths that occurred in several deaths in a short period of time, there was talk about the lack of adequate treatment facilities on this end of the state, and the long wait lists for those where you have to travel. I mean, there's always Hazelden, and then there's L.E. Phillips over in Eau Claire. Would you see, if somebody were to get something in this county, that helping between Pierce and Polk are also both growing counties where I'm sure there would be some demand for such a thing?
Most certainly there's a lot of demand for treatment, and there's a demand for affordable treatment as well. One that you mentioned of Hazelton, that's a very expensive program for somebody to be in, and a lot of these people who are drug users can't afford that.
Well, and that's what leads them to other types of crime, is their drug use, and they'll be stealing.
Yeah. Well, in and of itself, drug use of hard drugs, whether it be heroin or methamphetamine or cocaine, that's bad. As a society, we've deemed that that's bad. But it's more the ripple effect that we have from the drug use, the harm that people who have severe addiction problems cause to others, whether it be close to them, family members, often those are the ones hurt first, and then others in the community who suffer from property crimes or even sometimes crimes of violence because of somebody's addiction problems. So yes, most certainly having treatment available quickly, and available at something that's affordable is important.
Well, next question, where do you see, each of you, where do you see yourselves in 5 or 10 years from now? Because speaking from experience, 5 or 10 years goes by really fast. And pretty soon then you could be 25 years out. But do you see yourself being in prosecution that entire time? Or what would you like to aspire to? Do you want to go on to an attorney general's job, like follow Amber Hahn's footsteps? Or what do you see yourself doing?
I definitely see myself being a prosecutor at least for the next 5 years. I like to say I would like to be a prosecutor my whole life, just because I love the work, and I've only been in it for a few months. This is my first real job, so it's kind of hard to say. I'm really happy where I am. But in 5 years, I just hope that I've learned a lot more, and I feel competent in every situation I walk into, and that I just continue to gain knowledge, because right now the learning curve is very steep, and it will continue to be. But that's why I'm really grateful to be here in St. Croix County, where people are willing to help.
Great. Ed?
Yeah, likewise. I want to keep doing what I'm doing. I really enjoy prosecuting cases. I love trying cases. If you want to be a trial attorney and you want to take cases to trial, there's not really a better position to be in than a state prosecutor to do that. So,
you know how many, you said you were down La Crosse for a little over 2 years? About 2.5?
Almost 3.5.
Almost 3.5. How many jury trials did you have in that time?
I think there were a dozen of them.
Okay. All right.
And I think Matthew's done even more than that in his time here.
Like 12 to 14, somewhere in there. So. Okay.
In the couple years that you've been here?
Yeah, last year I had from October to April or May a lot of trials, back-to-back trials, things like that. And I think that's good for any young lawyer who's coming out, anyone that wants to be a trial attorney, is baptism by fire. I mean, right. I learned a lot. I learned probably more the couple of trials that I had than, you know, the 3 years of classroom work at school. It's a good thing.
Do you like being an assistant DA, or do you have aspirations to be a head DA someday?
Is my boss going to see this? No, I do like being an assistant DA, whether or not, at least for me personally, if there's an opportunity to be the DA or, you know, an assistant attorney general or things like that, I'm not worried about that. I'm not thinking about that at this time.
Right.
Maybe I will later on, but
well, one of the things that and whether it's St. Croix County DA or other prosecutors from larger counties where there's, you know, more than a handful of assistant DAs, that head DA job gets to be very administrative, kind of political, because you're having relations with the county board and going to a lot of meetings as opposed to being in the courtroom arguing and you know, getting the so-called work done as well. But does that have any intrigue for you to be more administrative than getting the trial experience?
Right now, I'd rather be doing trials. I know that.
Okay. Well, I will look forward to having you guys come back here 10 years from now, and then we'll talk about your experiences over those 10 years. But thanks a lot for being on the show and giving us an insight on what it's like to be an assistant DA here in St. Croix County.
Thank you
for having us.
thank you.
You bet. And thank you for joining us for another segment of Western Wisconsin Journal.